You're not trying to abrogate defamation. Not trying to make the claim, the common law claim of defamation go away. You're just trying to prohibit, the statute tries to prohibit frivolous claims, claims that are made for no apparent reason, no claim, like no support whatsoever for it, just for the purposes of dragging somebody's dick through the dirt, for lack of a better term.
Okay, we are here with Alex Ghibaudo. Why don't we just start out with you introducing yourself? Let us know a little bit about your firm, the areas of the law that you sort of practice in more often than others.
So it's a small firm. I have one other associate attorney and a staff of three. Do family law, do some appellate work, criminal defense, litigation, but mostly family law.
Okay, so this is a perspectives video that comes following quite a number of questions. I got a bunch of questions following our coverage of the Supreme Court proceedings with Abrams v. Sanson, and then we ended up getting another flurry of questions following a couple of dispositions, and it's a pretty popular couple of people that at least social media keeps an eye on. So I guess, what does SLAP even stand for? And also, what is really unique about the approach of anti-SLAP relief versus just winning a lawsuit the old-fashioned way, just a regular way?
Well, SLAP stands for Strategic Lawsuit Against Public Participation. And it's the anti-SLAP statutes are designed to terminate or end a case early before people are exposed to masses of attorneys' fees and costs for defending an action. So traditionally, you would have to wait until trial or on dispositive motions before you get, the case to end. In this case, you could file an anti-SLAP motion within 60 days of filing a complaint, and then the court has to address the statute and see if you could prevail on it. The unique thing about Nevada is that the statute actually provides for the attorney general to represent the attorney general or the DA to represent parties that are facing SLAP suits. That's one interesting aspect of it. But basically, it's just designed to terminate a case early before people are exposed to the process, because the punishment is the process. So the goal of a SLAP suit is to bury people in litigation, not to win. It's just to silence them by litigating it and forcing them to hire an attorney or taking their time to defend themselves in court.
I know for sure that a lot, I mean, me myself, before I was participating in the legal system, if I was faced with a lawsuit, just because I said something or posted something, I'd probably feel more inclined to just remove the post or stop saying whatever it was I was saying. And it seems to me like that's exactly what they're trying to prevent. The other thing that you mentioned that I actually had no idea about, so I'm going to go ahead and follow up on it, was you mentioned the Attorney General can actually get involved. Can you elaborate on that?
Yeah, so NRS 41.660 provides for that, for the Attorney General to take up a case for a defendant who's being sued in a SLAP case. So, yeah, it's a unique aspect of the statute, and I haven't seen it actually exercised here in Nevada, honestly, but it's available. It's there.
Okay, so let's go into VIPI versus Willick. Most of the sentiment is nobody, I guess people want a very clear win versus lose sort of reading from that case. And it was very analytical. There seemed like there were multiple factors or multiple points of analysis. And I guess you could answer this question, and you can also mention, I guess, your role in some publications in anti-SLAP suits, because I've heard that you actually represented somebody in the Supreme Court and got published as well.
Twice.
Oh, wow. So go ahead and I guess explain. People are wondering what the Supreme Court means by an initial burden, and also sort of, I guess, what the factors are and how they work.
All right. So a person who, if a claim or an action is brought up against a person based upon um, their petitioning activities or free speech activities made in furtherance of an issue in direct connection with an issue of public concern, then they could bring an anti-SLAP action. The first step of the analysis is to determine if the communication is made in furtherance of your rights petition, your rights free speech made in direct connection with an issue of public concern. So the Supreme Court, the statute lays out four factors or four situations that define that. So one of the situations, for example, is communications or statements made within the course of judicial proceedings. Those are privileged. Another is a petitioning activity to the legislature or complaints made to state administrative agencies. The last factor is the one that all of these claims are being brought under, and that's, I'll read it directly from the statute: communication made in direct connection with an issue of public interest in a place open to the public or public forum. So in this case, Sanson had Willick on his radio show. They had beef, to say the least. And then after that, Sanson posted 5 statements on his website that Willick alleged were defamatory. So Sanson's attorney, I think it was Annette Levy at the time, Annette Levy. I was involved in that case, by the way.
Oh, I had no idea.
Yeah, so I got my defendants dismissed with prejudice before even filing motions.
Oh, okay. So there were multiple defendants. All right.
There were multiple defendants.
Okay.
Yeah, it was the same defendants in the Abrams case. It was
Okay.
Willick suing Sanson and Abrams both at the same exact time. Both those motions went up at just about the same time back in 2017. So the first step in the analysis is that the person filing the motion has to prove by a preponderance of the evidence that it fits one of those factors, that the communication was made in furtherance of the rights of free speech or petition activity in direct connection with an issue of public concern. In this case, what was at issue were, Willick went on to Sanson's radio show to talk about AB 140's proposed legislation that would disallow district courts to use disability benefits of veterans, for example, in spouse support determinations. Willick opposed it. Sanson favored it. They had beef on their radio show, and after that, Sanson posted a whole bunch of statements that Willick took offense to, and he sued him. So the anti-SLAPP claim was simply that those statements were my free speech petitioning or free speech activity made in direct connection with an issue of public concern, and the Supreme Court agreed with them and went through each and every statement and how that fits the Shapiro factors to determine if it's an issue of public concern. So that's the case that I was involved in, and that's the case that I'm published on, is Shapiro versus Well. And that sets forth the factors to determine what is an issue of public concern. So bottom line on that, it's 5 factors, but the bottom line is it's got to matter to just, it's got to be more than a mere curiosity. It's got to be directed at more than just a handful of people.
Okay.
An issue of public concern.
So what they were saying apparently is that they met that particular burden, but I guess there's another part of the process where the other side can still sort of overcome it.
Actually, yeah, in that case, actually, the motion to dismiss, which was filed by Sanson, was actually denied by the district court judge Thompson, who was sitting like a senior judge. Mm-hmm. And so, because it was denied, he determined that there was no communication made in furtherance of a right to petition or right to free speech. It ended the analysis. If he would have determined at that point that the statements and communications were made in furtherance of the right to free speech, then the burden would have shifted to Willick to demonstrate a probability of success on the merits.
Okay.
So you have to go through the defamation elements and prove that he was defamed.
So, wow, apparently, even if you can show that it's an issue of free speech, I guess there's a lot more technical definition, but even if you can show that, you can still get around the anti-SLAPP statute anyway. You just have to sort of show something up front. You can't just wait.
Yeah, because you're not trying to abrogate defamation. You're not trying to make the claim, the common law claim of defamation go away. You're just trying to prohibit. The statute tries to prohibit frivolous claims that are made for no apparent reason, no claim, like no support whatsoever for it, just for the purposes of dragging somebody's dick through the dirt, for lack of a better term.
Okay, so the last thing that I noticed was there appeared to be some kind of specific attorney fee relief when anti-SLAPP was, I guess, successfully used. I don't know if you want to elaborate on that, and what happens, in an ordinary lawsuit, just how easy is it to get attorney fees versus if you get an anti-SLAPP motion granted?
Well, so if you prevail on a SLAPP claim, the statute directs the district court to award attorney's fees. So the direction is it shall award attorney's fees. The district court may sanction a party up to $10,000 also, but that's discretionary. So attorney's fees, if you prevail on a claim, you get attorney's fees. Mm-hmm. It's just like every other attorney's fees claim where you have to do a memo, fees, and costs and justify the actual time you spent, but you're going to get something out of it.
All right, I think we're just about done. I guess my last question will be just what was it that got you to get into anti-SLAPP suits? Was it just pure, a client wanted it, or were you kind of interested?
Just fell on my lap. But the Shapiro case, he came in and there was a website that was posted completely defaming him. It was utter nonsense, the stuff that was being said, alleging that my client engaged in felonious acts and conduct, that beat his dad and
Oh wow.
stole from him, and this, that, and the other thing, things that were demonstrably false. And he published that website, and so he sued him for defamation. And I was presented with an anti-SLAPP motion. It's the first time I even heard of it. We opposed it, and the district court granted it, and we appealed it, and the Supreme Court saw it the way we did.
Mhm.
That this wasn't an issue of public interest, because what was at issue in the Shapiro case was a conservatorship action in Jersey. It was about guardianship over an elderly father.
Man, it's you have a pretty thorough, I guess, understanding just based on the fact that it seems that you've argued from both sides of the coin on this specific issue. Thanks for coming
I
on.
did. The first, actually, it's funny because the first appeal in the Shapiro case, I was actually arguing that the anti-SLAPP statute was unconstitutional.
Wow.
I didn't prevail on that, but prevailed on the rest.
That's cool. Thank you so much for coming on. You're actually really popular. I get a lot of emails asking me to bring you back on over and